All right, let me get started. So if you pull up the notes here, I sent out this morning. All right. There's only 2 sections in this chapter. I kind of condensed it a little bit. Kind of focus on kind of some more kind of just basic kind of stuff here. So the judicial branch is our 3rd branch of government. All right. And so like all of these branches that we talked about, legislative, executive. The question that will be posed on the Constitution test, like about this for sure, is what does the judicial branch do when it comes to laws? All right. So the judicial branch, their job is to interpret the laws. So legislative makes, executive branch enforces, judicial branch interprets. All right. And this is all listed within Article 3. All right. Article 3 is a relatively short article, however, all right. But within the federal judicial branch, we have a kind of like a kind of a hierarchy of the court system. The highest court in the U.S. judicial system is the Supreme Court. All right. So this is, as far as like a lot with the Constitution stuff, there's probably of this branch, this one has probably the least amount of questions that kind of pertains to it. But as time has gone on, particularly as we become a nation that has become very polarized, meaning we've seen people that kind of like separate in a lot of their ideas and compromises on things. The judicial branch has become particularly very political and kind of important in for various reasons with them. All right. So within the Supreme Court, all right, and the kind of like again with a lot of these kind of branches here with the other branches. The Supreme Court's kind of unique because there's not really any like kind of like requirements per se. All right, the Supreme Court is technically made up of 9 justices. All right, a justice is basically just a judge within the Supreme Court. Now, why do you think 9 is a number that is significant? What's that? Yeah, odd number, right? So if you have an odd number, then chances are you're going to have a kind of there's going to be a decision made one way or another. All right. So the 9 justices are generally made up of the Chief Justice, who kind of serves as the head justice of the Supreme Court. They don't have any other, they're not any more particularly important per se. It's just kind of a title given to them. They at times can direct the kind of like the questions being kind of posed to the Supreme Court during certain cases. And then you have associate justices. All right, these are the other 8 justices. All right, so 9, I believe, is the number that was essentially established. It wasn't initially established in the Constitution. I don't believe the Constitution actually lists a specific number. And with the Article 3, like I said, it's relatively short. All right, and so we have extensive amounts of like essentially like kind of qualifications for representative, senator, and president, stuff like that. There's no real like kind of qualifications for becoming a member of the Supreme Court. All right. So this is the justices with an exception here. All right. When I put this image in here, the court today is a little bit more kind of like diverse than it had traditionally been per se. The guy in the middle there, that's John Roberts. All right, Roberts is the Chief Justice of the Supreme Court. He was appointed during the time of George W. Bush. The lady to his left, of course, is Ruth Bader Ginsburg, who passed away last year. All right, she was replaced by Amy Coney Barrett, and this was somewhat of the contentious in the sense that this was like her kind of like unveiling, if you will, was at a Rose Garden kind of conference there, where it was viewed as somewhat of a super spreader during the whole COVID thing. She was, and a lot of these, again, they're all kind of like confirmed by the Senate. All right. So they're appointed by the president. All right. This gives especially within this kind of era where people are definitely kind of entrenched in their kind of political ideologies. This has become a kind of key point in presidential elections. All right. Who becomes president can determine who is like, on the Supreme Court when things are when someone passes away or resigns. All right. Supreme Court justices are approved by the Senate, just basically a kind of simple majority. So it tends to kind of fall on party lines. they're appointed for life, right? There's no term limits on here. The idea is that the goal was to basically kind of have them transcend politics to a certain extent, where if you have a new president come in, they kind of appoint like their own justices. Can only be removed either by, obviously, if they resign themselves, but through impeachment. They are open to impeachment as well. All right. So this has become particularly very, very political. Like, so just recently, Justice Breyer, who's the oldest member, who's been on there, I think he was appointed, he was maybe appointed during even like maybe the Reagan administration. He's been there's been talk about him kind of maybe resigning, allowing Joe Biden to pick a younger justice that will have a chance for them to kind of have a more liberal kind of stance on the court. So you have justices, while they're supposed to be impartial, they will kind of carry people, will carry on their kind of political ideology at the time. So it's definitely become more of a political kind of appointment at times. All right. So first, as opposed to the Supreme Court justices, the first Supreme Court Chief Justice we know, John Jay. All right, this was during the cabinet of George Washington. The first African American justice, which for the most part, up until the 60s, it was basically all white dudes. Was Thurgood Marshall. Thurgood Marshall was also significant. He was a lawyer who essentially he brought the case in front of the Supreme Court, which ended desegregation in schools. The most famous case being Brown versus Board of Education. All right, Sandra Day O'Connor is the first female justice. She was appointed during the Reagan administration. And Sonia Sotomayor, her first Hispanic justice, was appointed during President Obama's. All right. So we have more women. We have more people of different diverse backgrounds. All right. As of the kind of last 30, 40 years, the court has become definitely a little bit more reflective of kind of the population, if you will. All right. I'll kind of show you some images here. So there's John Jay on the left, Thurgood Marshall. All right. When he passed away, he was replaced by Clarence Thomas, who was also African American, but he's more of the kind of more conservative persuasion. Sandra Day O'Connor on the left, and Sonia Sotomayor. All right. And then a kind of with the kind of ultimate power of the Supreme Court, which is something that is actually kind of not mentioned in the kind of technically in the Constitution, but kind of gives the kind of Supreme Court this idea where they can put a check on kind of both branches, is this concept of judicial review. The idea, which is kind of how the kind of the job of the Supreme Court is really kind of determined, is whether kind of we talk about when they interpret, they're interpreting whether laws are kind of, or presidential actions like executive orders, whether they are aligned with the Constitution, whether they are constitutional or what they consider unconstitutional, right? And at times, certain things change over time, right? Like the idea of kind of separate facilities based on race. In one case, Plessy versus Ferguson stated that was fine as long as things were equal. We come to find out that's not. And so Brown versus Board of Education kind of reverses that. All right. So the court can also change its interpretation of law as the time changes as well. All right. So I'm going to kind of play this little video here that just kind of talks about the whole concept of judicial.
Hi, I'm Craig, and this is Crash Course Government and Politics. And today we're going to talk about the most important case the Supreme Court ever decided, ever. No stand, not Youngstown Sheet and Tube Company versus Sawyer, although that is one of my favorites. Loves me some Sheet and Tube. And no, it's not ex parte queering, although I do love me some inept Nazi spies and submarines. And no, it is not Miller v. California. Get your mind out of the gutter, Stan. We could play this game all day, but this episode is about judicial review, the most important power of the Supreme Court and where it came from. Don't look so disappointed. This is cool. When you think of the Supreme Court, the first thing you think about, other than those comfy robes, is the power to declare laws unconstitutional. The term for this awesome power, the main check that the court has on both the legislative and executive branches, is judicial review. Technically, judicial review is the power of the judiciary to examine and invalidate actions undertaken by the legislative and executive branches of both the federal and state governments. It's not the power to review lower court decisions. That's appellate jurisdiction. Most people think of judicial review as declaring laws unconstitutional, and that definition is okay. But legal purists will quibble with you since judicial review applies to more than just laws. Appellate courts, both state and federal, engage in some form of judicial review, but we're concerned here with the federal courts, especially the U.S. Supreme Court. The court has the power to review the following. 1. Congressional laws, aka statutes. Since judicial review is a form of appellate activity, it involves upholding or affirming the validity of laws, or denying it, invalidating the law in question. You might think that the Supreme Court does this a lot, but it doesn't, and historically it almost never happened before the 20th century. If the court were always striking down congressional statutes, it would be hard for people to know which laws to follow, and you'll remember one of the main things that courts do is create expectations and predictability. For instance, you could predict that I would eventually be punching this eagle. Another reason why they don't invalidate laws often is that if the court frequently overruled Congress, the court would seem too political and people would stop trusting its judgment. If the court has any power at all, it largely stems from its prestige and reputation for being impartial and above politics. No one has any problems with the Supreme Court decisions at all. 2. The court can also overturn state actions, which include the laws passed by state legislatures and the activities of state executive bureaus, usually the police. The power to review and overturn states comes from the Supremacy Clause in the Constitution. Most of the time that the Supreme Court extends civil rights, it comes out of a state action. A good example is Brown versus Board of Education, where the court struck down the idea of separate accommodations being equal in the context of state public schools. 3. The court can review the actions of federal bureaucratic agencies, although it will usually defer to the bureaucrat's expertise if the action is consistent with the intent of the legislature, which the court usually finds it is. The court almost never strikes down congressional delegation of power to the executive, although you might think that it should. The 4th area where the court exercises judicial review is over presidential actions. The court tends to defer to the president, especially in the area of national security. The classic example of the court overturning executive action happened in U.S. versus Nixon, where the justices denied the president's claim of executive privilege and forced him to turn over his recordings relating to the Watergate scandal. More recently, the court placed limits on the president's authority to deny habeas corpus to suspected terrorists in Rasul versus Bush. So the Supremacy Clause gives the court the authority to rule on state laws, but where exactly in the Constitution does the power of judicial review come from? Trick question, it's not there. Go ahead, look, I'll wait. See, not there. Wow, you went through that whole thing really quickly. Fast reader. The crazy thing is that the power of judicial review comes from the court itself. How? Let's go to the thought bubble. The Supreme Court granted itself the power of judicial review in the case of Marbury versus Madison. You really should read the decision because it's a brilliant piece of politics. The upshot of the case was that Chief Justice John Marshall ruled that the court had the power to review, uphold, and strike down executive actions pursuant to the Judiciary Act of 1789. And in doing this, to strike down part of that federal law. How we got there was pretty cool. So Marbury was an official that President John Adams, at the very end of his term, appointed to the position of Justice of the Peace. When Marbury went to get his official commission certifying that he could start his job, James Madison, who was Secretary of State, refused to give it to him. So Marbury did what any self-respecting petitioner would do. He went to the Supreme Court for a writ of mandamus that would force Madison to give Marbury his job. This is what he was supposed to do, according to the Judiciary Act of 1789. What Marshall did was brilliant. He ruled that, yes, Marbury had a right to the commission, but that the Supreme Court could not grant his writ because the law directing them to do so was unconstitutional. This is brilliant for 2 reasons. First, by the time the case came before the court, Thomas Jefferson was president. Those of you who remember Crash Course U.S. history will recall that that less handsome man told you that Jefferson was a Democratic Republican, while Adams, Marbury, and even Marshall were all Federalists. By ruling against his own party, Marshall made a decision that was favorable to Jefferson and thus likely to be supported. The second move is even cooler. Marshall's ruling took the power to grant writs of mandamus away from the court, making it look weaker, while at the same time giving the court the power to declare the law that had granted it the mandamus power in the first place unconstitutional. So by weakening the court in this instance, like Daredevil going blind as a kid, Marshall made it much stronger for the future, like Daredevil getting stronger in the future. Thanks, Thought Bubble. So that's where judicial review comes from, but that still leaves big questions. A big question is, why has this ruling stuck around and hasn't been overturned by other laws or later court decisions? Another question is judicial review a violation of separation of powers? Some say that it's judges making laws, and that's an anti-democratic usurpation of the legislature's power. Let's talk about this ruling's longevity first. Remember when I said last time that the Supreme Court rulings are binding in lower courts? You don't remember, do you? You were sleeping. Wake up. Well, in general, Supreme Court precedents are binding on future Supreme Courts too, because of the principle of stare decisis, which is Latin for let the decision stand. This doesn't mean that future Supreme Courts can never overturn the decisions of prior courts. It's just that they try very hard to not do it. This idea of precedent is one way that judges can be said to make laws. Appellate decisions are like common law in that they're binding on future courts and constrain their decisions, and because they don't have to be grounded in a specific statute. Other courts have to follow the higher court's interpretation of the law, and this interpretation has the effect of redefining the law without actually rewriting the statute. On the other hand, appellate decisions are technically not common law in that they are only binding on courts, not executive agencies or legislatures. They are, however, signals to courts and legislatures about how courts will rule in the future. Maybe an example will help. If you watch cop shows or you get arrested a lot, you probably know something about Miranda versus Arizona, which gave us the Miranda warning. You have the right to remain silent and all that stuff. Hopefully you've never heard that in person though. But hey, we're not here to judge. That's what the courts are for. Okay. In that case, the Supreme Court threw out Miranda's conviction because he hadn't been told that he had the right to remain silent. Without knowing that he didn't have to talk, he made a confession that got him convicted. The court didn't rewrite Arizona's law, but it sent a signal to Arizona's law enforcement agencies and those in all the other states that in the future, courts would throw out the convictions of defendants who hadn't been informed of their rights. As a result, police procedures changed in every state, and now the police are supposed to read their Miranda rights to anyone they arrest. So those are the very basics of judicial review. We've probably raised as many questions as we've answered, but that's why we're making a bunch of these videos, so we can teach it all. All of it. Anyway, the big concern for many is that cases like Marbury versus Madison, which give courts the power to strike down pieces of legislation, overturn the judgment of the elected representatives that made the laws and violate the idea of separation of powers. Well, that is a thorny issue, but it's one we don't have time to de-thorn today. For now, understand that judicial review is how the courts work in practice, and not necessarily a defined power granted by the Constitution. Just remember, the executive and legislative branches also operate with a lot of implied powers that aren't explicitly granted to them in the Constitution. That's because the governance of the United States has evolved and changed over time to hopefully suit the needs of the country as they change over time. Thanks for watching.
So, like I said, kind of the short case here that establishes judicial review. Is Marbury versus Madison, 1803, which was a case that was over the Judicial Act of 1789. All right, and so, like I said, the idea behind it was essentially it basically kind of overruled or determined that the kind of Judicial Act of 1789 was actually unconstitutional. This sets the pattern for kind of the Supreme Court to essentially, basically, kind of like interpret the laws, if you will. All right. So this is kind of unique in this branch that it didn't necessarily. They're kind of the idea that we have with laws, what the Judicial Branch does, actually emerges from a case itself. All right. John Marshall is the Supreme Court justice who kind of established that. Probably historically, probably one of the more famous Supreme Court justices. There he is. I'm gonna skip this so we get into so when cases get brought in front of the Supreme Court, and there's not a lot of cases. That's the cases that a lot of times they have to go. And we'll talk about kind of the lower court system. You have to issue a writ of certiorari, which basically is a written request. All right. Within this, you have to have like kind of a rule of 4, at least 4 of the 9 justices move to vote to hear a case after reading the writ. All right, and then if that does not go through that, then it gets remanded. It basically returns to a lower court, usually what's called an appellate court, which we'll kind of talk about in that. All right, and essentially you have a limited time that the lawyers to present this. They have a limited time on basically to give their arguments, and they answer questions from the justices. There's no like cameras within the court, but a lot of there's recordings of these. All right, and you'll hear the justices kind of ask questions and kind of in a sense like basically kind of like try to get more out of the kind of lawyers here. This is an example of restored. And then when hearing the case, like I said, Supreme Court cases here by oral arguments, lawyers to the people that stand up, they have 30 minutes to present their arguments. So you got to be concise, you got to be clear. All right, you can't kind of just basically kind of like him and haw and stuff. All right, each justice has 1 vote and decisions reached by a simple majority. So a lot of times you'll have like certain cases that are very, very contentious, usually a 5-4. All right, some that are unanimous, sometimes you'll have 9-0 and stuff like that. Obviously, that's where the odd numbers would be kind of like plays a role here. All right, and each of them, each justice also then kind of has a say on why they came to a certain decision. All right, that is where we have opinions. Opinion is basically explanation. Let me just hit this one here. I'll send out a recording later today for you guys to kind of look at these. Not like you were kind of really good. So, I'll send out the recording. You can finish up the notes and send them to me later. All right. So you fast forward each of those. I'll go right here. Concurring opinion, and then dissenting opinion. And I'll put this up in this morning. You can stop it, pause it, flip it, do it second. I'll put up the recording, guys, if you need to kind of give a copy of them. All right.